Hi everybody, it's Charles from Novak Migration. Good to see you again. Today a few words about who can be included as a dependent in your visa application. Let's say you are the main applicant for a visa, either permanent or provisional or temporary, and you would like to include your dependents as well. So who can be included and what sort of the evidence needs to be provided for the dependents. So essentially, primary applicant must satisfy the requirements for the visa, whatever sort of visa it is. Let's talk about the skilled visas. Let's put the partner visa aside because that's the totally different story. But let's say about 190, 189, 491, ENS 494, 188, the business visa, the talent visa under the GTI or otherwise. All of those visas based on skills, qualifications, work experience, and so on and so on. So the main applicant needs to satisfy all of the requirements for the visa as the primary applicant, which is the skills, work experience, whatever is the requirement, okay? And dependents essentially needs to prove that they are dependents, that they are related and they can be included as the dependents in the application. So who am I? Charles, also my Christian name is Karol, but for locals Charles, just to make it easier. Novak. Novak is my last name, and Charles from Novak Migration. Your Mara number listed over there. You can check me on the Mara website. If you wanna get in contact with us, shoot an email to contact@novakmigration.com.au or give us a call to our office if you need any assistance with your visa refusal. We are dealing with refusals, AET as well, and so on and so on. All right, let's get to the point. Who can be included in the application as dependent? In general, it's only about your partner and children. Okay, children, minors under 18, however, over 18 and over, under some circumstances can also be included in the application. So for partners, there are a couple of different ways how you can prove that you are in the relationship. If you are married with your partner, no brainer, you're providing the marriage certificate, some evidence that you are living together, financial aspects, and so on and so on. I will discuss the 4 pillars of the relationship a bit later in this webinar, but if you're married, that's fine. Should be usually quite straightforward. If you are in de facto relationship, different story. Normally, you would have to prove that you have been at least 12 months in the de facto relationship before the visa, the date of the visa application. However, there is a tricky bit where you can still get away with that if you are living in Australia. So if it was less than 12 months while you were in the relationship with your partner, there are the circumstances, there are the situations where you can still include your partner, where you can still prove that you are in de facto for the visa. All right. So Section 5CB of the regulations describes the requirements for the de facto partners. So essentially what they say, for de facto partners, for the purposes of design, the person of de facto partner with another person, same sex or different sex, we are dealing with same sex relationships all of the time. So it does not have to be, man, woman, two men, two women, not a problem. De facto relationship with another person if they are not in a married relationship. If you are married, you are not in de facto. But they have mutual commitment to shared life to the exclusion of all others. So it's not a boyfriend, girlfriend, it's a partner. It must be in the mutual. You must have this mutual commitment to shared life, not multiple relationships. So I know in some cultures it's quite normal that men have got a few wives. In Australia, sorry, you will have to pick one. because the polygamy is not allowed over here. Relationship is genuine, continuing, and they live together or do not live separately on apart on the permanent basis. This one is very important. People are usually thinking that you must live together to prove your relationship. It's not correct. It's do not live separately and apart on a permanent basis. So there could be situations where the couple is not living together for some factors, sometimes beyond their control, and sometimes because of the choice. You know, the COVID, for example. Somebody was overseas, somebody was in Australia. They couldn't prove that the relationship was for more than 12 months. They couldn't get the visa, they couldn't get the travel exemption. Beyond the control. So in some cultures, if you are not married, you cannot live together, and so on and so on. So in general, they want to see that you are living together, but there are some circumstances where it is sort of fine if you are not living together, but still you need to prove that the relationship is genuine. How to prove that? I will explain that a bit later. Not related by family. This one is tricky, and with partner visa applications, there is the question whether the sponsor and the visa applicant is related by family, and a lot of people are thinking, yes, we are married, we are family. That's not the intention of the question. The intention is if you are related by blood or some sort of the family act. So if you are cousins, siblings, that's sort of the relationship by family, mother, son, and so on and so on. So if there is that family relationship in the terms of the blood relationship or adoption or step siblings and so on and so on, it's the question about this sort of the family relationship, not about whether you are married or not. So the 12 months of the relationship before the visa application for de facto would have to be evidenced. But if you are not in the proper de facto relationship for at least 12 months, you can get away with that if the relationship would be registered under the state territorial law prescribed in the Acts Interpretation Act. So simply speaking, if you would register your relationship in one of the states which are being allowed by the Acts Interpretation Act, you may get away with this 12 months of the relationship requirement. And currently Victoria, Tasmania, New South Wales, ACT, QLD. These 5 states, relationship registered in these 5 states is being accepted to waive this 12 months of the de facto relationship. Northern Territory and South Australia. Yeah, it's current, 1st of October 22. So South Australia, Northern Territory and Western Territory, you can register the relationship over there, but it will not waive the 12 months of the de facto requirement, okay? So Victoria, Tasmania, New South Wales, ACT, QLD. So if you are living in Australia, or at least one of you is living in Australia in one of these states, and you would essentially have to check what are the requirements for the particular state to get the relationship registered, you might get it registered, and that will give you, waive the 12 months of the de facto relationship before the visa application. To register your relationship, if you are still legally married, there is no way you can register your relationship. If your relationship with your ex is still registered, you might need to deregister your previous registration to get the new registration. So it's not like you can register your relationship because you want to register. And also keep in mind that the de facto registration is not a marriage, but it takes some legal obligations. There are some legal obligations. You're almost as married, so it's not like you're registering and that's it. Get some legal advice if that's something you would really want to do. That's from the migration point of view. The registration of the de facto is waiving the 12 months of the de facto cohabitation before the visa application. However, whether that's something you like to do with your partner, you would have to talk to the lawyer who is dealing with the family law and do some your own research, okay? So that's how you might get away with this 12 months of the de facto relationship requirement before the visa application. There are some types of the visa which are not prescribed in the relevant legislation where the 12 months of de facto is required, but for those 6 months it's considered as enough. I think New Zealand dependent and maybe some other ones, I don't remember exactly which ones, are one of those visas. But in general, de facto 12 months. If you are not in 12, if you have not been in de facto for at least 12 months, then registering in your relationship with one of these states may help with getting away with that. But the registration of the relationship, it's not enough. Marriage, it's not enough to prove that you are in the genuine relationship. All right. 4 pillars of the relationship. So nature of the household, social aspects, financial aspects, and the commitment to each other and how do you see your future. These are the pillars of the relationship which are prescribed in the relevant legislations for the partner visas essentially, but these also apply to any other visa when you are including your partner in the application. So nature of the household, if you are living together or not living apart on the permanent basis, so that's evidence. If you are living together, statement from both of you, from the main applicant and dependent and your partner about your relationship, tenancy agreement or some major household purchases, or if you own the house together, if you have got mortgage on both of your names, that's sort of the evidence. Social aspects, that's the statements from family and friends that they recognize you as the couple. For the partner visa, there is the 888 form, which is a template for the statutory declaration for the partner visa. However, I'm telling to my clients, yeah, you can use it for the other visas as well, and it's just a template for the statutory declarations, and Home Affairs case officers are happy as to approve that to see that sort of the evidence. The photos with some family and friends, so photo album, 10-15 photos in various social situations. Take the photo, put the photos into the Word document, put the description, when taken, where taken, who is in the photos, what was the situation, to show that you are actually, showing that you are in the relationship with the other people. Financial aspects. The easiest is to have the joint bank account. Sometimes people don't have the joint bank account and it's becoming tricky, but still doable. So if you are making some purchases from your own accounts, then showing that you are transferring money to each other, or that you are making joint purchases or paying for joint items, and so on and so on. Commitment to each other and how do you see your future. Declaring the other one as the next of kin at school, at work, beneficiary as in the superannuation, wills, this kind of stuff. And again, your statement. What I'm asking my clients to do, write a statement about your relationship and divide it into 5 chapters. The first chapter, how your relationship developed. The second chapter, describe how do you fulfill the requirements for the nature of the household. The third chapter, social aspects, how do you socialize with the other people. Fourth chapter, financial aspects, and the fifth chapter, commitment to each other. How do you see your future? And then whatever you write in that statement, then provide evidence for all of those things. That's the best way to go ahead. So partner, either married or de facto. If you're in de facto, you will have to provide the evidence that you were in the relationship for at least 12 months in de facto before the visa application. If you're in Australia, living in one of those states, you may potentially register your relationship and get away with 12 months before the visa application, but still you have to provide the evidence for the 4 pillars that you are in the genuine relationship. Okay, for partner visa, evidence for 4 pillars is a must. You must cover each and every pillar. For the application as dependent, Case officers may, consider any evidence, and sometimes they might not need to consider any of those pillars. It's not that strict as for the partner visa, but do yourself a favor and provide the evidence for each and every aspect of the relationship. Children. All right, so if the children is under 18 years old, and both of you are parents, no brainer. Birth certificate, passport, more or less that's it. If the child is 18, alright, so if the child is under 18 and only one of you is the parent and the other person is not a parent, because he or she have been in the relationship with somebody else, and now you are applying for the visa with your partner and their child, which is not your child. It's fine. Dependent of your dependent is usually considered as your dependent. Okay. If child is under 18, in general, you must provide form 1229, and the other parent must provide consent that they are okay for the child to get the visa, either temporary visa or permanent visa. There are the situations where the other parent is not willing to provide the consent, and you have got problem. So if your dependent, your partner who is taking care of the child, has got the court ruling that your dependent, your partner, is having all of the rights to take care of the child and make a decision where the child resides, the court ruling is fine. If there is no court ruling, then you might have a problem. Your partner might have a problem with getting the visa for the child. You might end in the court, essentially. But Form 1229 from the other parent of the child, it's signed by the other parent of the child and notarized, and the copy of some ID also notarized with a signature. That's what usually is enough. All right, so that's for minors, for the children who are 18, under 18 years. If the child is over 18 years or over, may still be included in the application. Usually it's up to 21, okay? So 18 up to 21, if the child is still dependent, if it's financially dependent, if it's studying, if it's essentially not working, can still be considered as dependent and can still get the visa as the dependent. But it must be single, cannot be in the relationship. So not in the relationship, preferably still studying and not working, and dependent on the parent. All right, so not fully dependent, but mostly dependent. So if they would have some sort of the work, getting some pocket money, not ideal, but could be fine. So 18, 21 in general, up to 21, sometimes 23, sometimes 25, but in general 21, it's fine. There are some transitional arrangements for the members of the family unit who might no longer be considered dependents, who can still be included in the application. So essentially one of those is the ENS visa under the transition stream. So if somebody was a member of the family unit included in 482 visa or 457 visa, and then is applying for the ENS, that person, even if they are no longer a member of the family unit, no longer dependent, can be still included in the application. That's interesting, and not many people are, even migration agents are knowing that. All right, so. For children, sort of evidence, in general, birth certificate, if the minor, and 1229, if the minor. If the child is 18 or over, then you will have to provide, of course, birth certificate. 1229 is not required for the child 18 and over, because they're already adults, so the other parent does not have to make a decision where that person would live. But 47A, as I remember, there is the form which would have to be filled by the child, by the dependent, and some evidence that the child is still studying, that the child is financially dependent, preferably still living with the parents, and so on, would have to be provided. Okay, so that's for children. Parents, I'm getting this question, if parents could be included in the application as dependent. No, simply speaking, no. Years ago, I think it was until 2015 or 16, parents could be included as dependents. But from that time, for last 5, 6 years, no. Only your partner and children could be included in the application as dependent, generally speaking. All right. So that would be more or less it.